is claiming trial by ambush from the defense. Trial by ambush. How is the defense trial by ambush when they have interviewed every single one of these witnesses before in the last 5 years since this case started? They've interviewed every single person that has been on there. They have written, transcripted interviews and video interviews of all of these people. And so how they are relevant, these witnesses will testify if and when they are needed to add additional facts or fill in the blanks that the state will no doubt leave out in their case in chief, and they'll be called accordingly. I need them to lay perhaps foundations for evidence presented by the state. The same with Lonnie Dorkin. I need his testimony will be required if and when it's necessary to rebut digital information that the state will bring forward during trial. I feel like the state is trying to say, okay, if you want your speedy trial, guess what? We're not gonna let you defend yourself. Guess what? You can't have any experts. And guess what else? You can't have any witnesses. You can't have anybody speak in your behalf. So good luck. Have a nice day.
All right. Well, that's why attorneys sometimes take a long time to prepare for a trial, because they need to give notice of what all the testimony their witnesses are going to give. They need their experts to prepare reports. That's why your prior attorneys and your current attorneys were asking for more time to prepare the case. So you can't really have it both ways, that you want your speedy trial rights, but you don't want to give notice to the other side of what your evidence is.
I don't.
Well, hey, folks, day one of the Lori Vallow Daybell trial was nothing short of a slow-motion legal disaster. Defending herself in court, Lori challenged everything from witness lists to expert testimony, often stumbling through objections and misunderstandings of the law. But Judge Justin Beresky, he remained calm, composed, and frankly sharp as a tack. He balanced his firm rulings with a surprising amount of compassion, even as Lori unraveled in real time. From arguments over shock belts to accusations of prosecutorial misconduct and a bizarre attempt to make our friend journalist Nate Eaton a defense witness. This hearing had it all. So join us as we break down every jaw-dropping moment from the first day in court. Hey everybody, welcome to Profiling Evil. Please hit that like and subscribe button. Now I'm just getting back from a few days of filming on a documentary, and I'm turning around and jumping in the car to head out of town to do a conference. But I wanted to cover a couple of things that really jumped out at me last night and share a conversation I had with Nate Eaton. Now the first day of Lori Vallow Daybell's Arizona trial felt like being stuck on a ride that you knew was going to crash, but you still couldn't look away. And right in the middle of it all stood Judge Justin Beresky, somehow managing to hold the reins with equal fairness and firmness, measured with patience, and at times a sense of compassion that was really hard to miss. Well, things really kicked off with Judge Beresky explaining how the next wave of jurors, which was about 40 to 60 people, would complete the questionnaires, and then they would start the in-person voir dire. And I know it's voir dire and all kinds of different names, but I've always called it voir dire. But before anything could get rolling, Lori jumped in with an objection because, of course, she did. Well, she didn't like the phrasing in the questionnaire, and she insisted her denials of guilt be bolded and underlined. The judge calmly let her know that that ship had already sailed. The form had been finalized and sent out, and he could have easily dismissed her challenge with irritation, but instead he gave her the space to make her point before moving on. And again, this compassion, I think, is going to wane over the course of this trial. Well, next, Lori tried to boot Detective Daniel Coons from testifying as a trajectory expert. She questioned whether Coons had just taken a weekend course and suddenly earned the title of firearms expert. How arrogant. Her frustration was visible, even if her legal footing was shaky. Now, Judge Beresky, again, didn't snap back. he walked through the legal standards, explaining that Coons had been properly noticed and said that he'd take it under consideration in her claims. No dramatics, just measured guidance from the bench. And yes, this officer will be expected to be an expert. When the state presented 3 witnesses to support their theory of premeditation and motive, this was Christina Atwood, Nancy Jo Hancock, and Kay Woodcock, Lori complained. She argued that their testimony was secondhand at best, and that they'd all been watching Dateline and they were gossiping with each other. Just like the state fired back, saying these women had personal interactions with Lori, and at least one of them heard her actually talking about demonic possessions months before the murder occurred. And that, folks, ain't nothing. Still, Lori pushed to have them excluded, but Judge Beresky acknowledged her concerns and then ruled that they would be testifying. And in a moment that showed again his patience one more time, he reassured her that she'd have every right to cross-examine them about any bias or hearsay. Now, the weirdest detour of the day came when Lori tried to list Nate Eaton of East Idaho News as a defense witness, saying he might help impeach other people's testimonies. The real kicker? Eaton believed this was just a ploy to keep him out of the courtroom, and so he brought in a lawyer to back that up. Now, Lori insisted that she had no idea that Rule 615 would bar witnesses from observing trial proceedings. The judge, again, in a measured approach, acknowledged that Lori may not have been fully understanding the implications and ultimately struck Eaton as a witness, allowing him to stay in court. Nate and I had a chance to talk about that, and I want to play his comment.
Hey, Mike, I just have to say it was a relief to have my name struck from the witness list. I'm really pleased with how the judge ruled. You know, a reporter never wants to be the story. And also, I really had nothing to add. I didn't start covering this story until December of 2019, and all of these alleged crimes happened in July, months earlier. So, yeah, I'm pleased with how the judge ruled. I think that, I know I'll be able to be in the courtroom now every day. Actually, that's where I'm going right now. Head into the courtroom as jury selection continues, and we will see what the next few weeks bring for this trial with Lori, the lawyer, representing herself. Thanks, Mike.
Now, one of the rare moments of agreement between the defense and the prosecution was over the protection of private information. With emails and phone numbers potentially appearing in evidence, the court barred the media from broadcasting or printing full personal contact details. This is incredibly important. These people don't deserve to have that out there. In this particular case, Lori nodded in agreement, and perhaps it was the only nod of agreement during the day. But this is where things really went sideways again, because the state argued that Lori's list of witnesses was vague, including the fact that many hadn't been subpoenaed and most had not even been interviewed. They feared this trial by ambush with surprise testimony popping up mid-trial, and they argued against it. Well, Lori countered that the state had interviewed many of these people in the past 5 years, and if she needed to call somebody to, quote, fill in the blanks, well, that was her right. She also complained that she couldn't find people herself because she was limited by jail conditions, a lack of access to phones, and frankly, a phone system that didn't allow her to call people freely. And here's where Judge Beresky gave one of the most telling remarks of the day, not just for its truth, but how it gently cut through Lori's spiraling frustration. He said, quote, "Well, that's why attorneys sometimes take a long time to prepare for a trial, because they need to give notice of what all the testimony of their witnesses are going to give. They need their experts to prepare reports. That's why your prior attorneys, speaking to Miss Daybell, and your current attorneys were asking for more time to prepare for the case. So, speaking again to Lori Daybell, the judge said, you really can't have it both ways. You want your speedy trial rights, but you don't want to give notice to the other side." Close quote. Well, it was a moment that encapsulated the entire courtroom dynamic. Lori, passionate and paranoid, arguing from instinct, not from the law. And the judge, patient yet pragmatic, guiding the process without allowing the courtroom to veer completely off the rails. Now, this is when Lori also launched a long rant about the state reading confidential messages between her and her Idaho appellate lawyers. She claimed that her rights had been violated and that the state exposed her attorney's IP address and even floated the idea of federal crimes. But again, the judge methodically explained that the messages weren't sent through approved confidential line channels. They came from multiple IP addresses, not the protected one that was tied to the secure jail line. So in essence, what he said, and in fact, I think he actually used these words, is if anybody violated the rule, it was your own attorney, Lori. Well, the judge ruled that the state can't use or share any of those messages, but also indicated that he found no misconduct and he denied the motion to dismiss. Then Lori went on a different tack and she accused the prosecution of interfering with her access to public records and giving legal advice to Nate Eaton. Again, the judge let her speak. He didn't cut her off, but he made it clear there was no basis for dismissal. So the next question came up about convictions and what the jury is going to be able to hear, because the prosecution wants to tell jurors about the 7 felonies that Lori was convicted of in Idaho. The judge suggested that the 2 sanitized versions might be allowed, likely including the murder and grand theft by deception counts, if Lori decides to testify. And I think you can be guaranteed she's going to testify. And if you think the last time when she made a statement at the end of her trial was wacky, I can't wait to see what this one is. But it's just like watching a slow-moving train wreck. Well, as the hearing wrapped up, Lori raised one more issue, and it goes back to a video I posted yesterday. She didn't want to wear that rack belt. That's the shock belt worn under her clothing that allows deputies to remotely restrain her if needed. Her argument, she said, "Judge, if the sheriff's office posts armed deputies at the courtroom doors, then there'd be no need for her to wear this belt at all." Well, she pointed to a recommendation from the jail that suggested less visible security, that like stationing the deputies near the doors could eliminate the need for restraint altogether. But the judge wasn't having anything to do with that. He cut through the debate with finality, saying that she would wear the belt. Now, she wouldn't have to wear leg shackles, which might be visible to jurors, but the rack belt, however, would be concealed and necessary for courtroom safety. In essence, he said, "Lori, you're representing yourself. You'll need to move around the courtroom. You're not getting out of this belt. Get over it." Well, it was one of those few moments where the judge showed zero leniency, not out of cruelty, but out of realism. Security matters, and no amount of arguing about alternate setups was going to change that. And as he was talking about that, he also laid out the courtroom seating chart, saying that the first rows behind each table, the prosecution and the defense, would be reserved for next of kin and family members. The very back row, they were set aside for the media, and the middle rows are first come, first serve. And there's one final caveat. Any defense witnesses that are still on Lori Vallow Daybell's list, including family, would be excluded from the courtroom until they testify, per this rule of exclusion. Watching Lori Daybell represent herself was like watching a law school dropout trying to perform a brain surgery. Now, what stood out on day one wasn't that Lori's spiraling defense was heading down rapidly. It was Judge Beresky's calm resolve. He didn't condescend. He didn't lash out. He let her make her record even when it barely made sense. He gently corrected her legal misunderstandings, and he gave her space to argue, even when those arguments were rooted in more emotion than in law. Now, he's not enabling her chaos, but he is respecting her right to be heard, even as that chaos slowly unfolds in real time. Now, opening statements are going to be set for April 7th if they can get through all the jury selection. And if day one is any sign of what's to come, this trial is going to be as captivating as it is tragic. So I hope you'll take a moment to drop your thoughts in the comments section below, especially your thoughts on Lori's decision to represent herself and the judge's reaction to that. What stood out most to you during the first day of trial? Did the courtroom chaos surprise you, or was it exactly what you expected? And make sure you're kind to each other, and let's work through this disturbing case together. I want to thank you for tuning in to Profiling Evil. I really do appreciate your support, and I want to remind you that you can find us on Facebook, Instagram, YouTube, and Twitter. And for real-time updates and deeper insights throughout the trial, you can even do some things like check out our website. Now, if you enjoy audio podcasts, don't forget to subscribe to Profiling Evil podcasts on your favorite podcast platform. And if you want more information, go to our website at profilingevil.com, where you can sign up for our digital newsletter, The Bolo. And if you're a fan of true crime books, you can pick up my books, Deceived, an investigative memoir of the Zion Society cult, or She Knew No Fear, the incredible story of the murder of my great-great-grandmother in 1891, and how I solved that thing 130 years later. So thanks for your support of Profiling Evil. We'll see you soon at the next crime scene.